Hi, I'm Susan Grissom with Grissom Law Firm. We're a law firm located in Johns Creek, Georgia. I'm an authorized and licensed attorney to practice in the state of Georgia, and I focus my practice in the areas of estate planning, uncontested probate, and small business law. Today I want to talk to you about a question that I receive a lot, and that is, should I or can I add my children to the deed for my home so that it avoids probate? There are many reasons why this sounds like an instant answer to the need to go through probate. If we add our kids onto our deed, then when we pass, we can have it joint with rights of survivorship and it will simply pass to them. They won't have to file anything in the probate court and their life will just continue on. There are other positive reasons why people look at doing this. For instance, there's no delay by doing that because when we avoid the probate process, we can just go ahead and sell as soon as we have a death certificate. And lastly, one of the reasons why we might add our children is because we're trying to reduce a taxable estate. And so by adding them to our deed, we may be reducing the estate we have remaining by making a gift during our lifetime. All of these sound very positive. On the other side of that, though, there are things to consider, such as, are your children all adults? Because if you decide to sell that home, they need to be able to execute the sales documents to sell. If you have minors named, you may have to go to court and have a conservatorship put in place and then petition the court for permission to sell the property. And then these funds may become under court management until your minor turns 18. Additionally, if you choose to sell and you have adult children, they're still going to be a part of the process. They need to participate in the closing. They'll likely have checks written to them for their portion of the proceeds, and it may affect their taxes as well. Lastly, if your child is involved in some sort of a civil litigation or has creditors coming after them, their name is on that piece of property, and so it is part of their estates and could be included in any sort of a lawsuit settlement or judgment that were to come down. Another item that's always worth consideration is while this might remove it from your taxable estate, by moving your home into joint ownership with your children, they are going to see a capital gain when they sell the home. What I mean by this is when you inherit property, right now under current tax law, it steps up in cost basis to date of death value. However, if you put your children on that home during your lifetime, they will not get the benefit of this step up in cost basis, and they'll pay capital gains from the date of your purchase value until the date that they sell it. There are alternatives to doing this that are worth considering. One of the main ways that we avoid this need to go through probate is by establishing a revocable trust. A revocable living trust will allow you to avoid the probate of that asset. It will also allow you to remain in control for the rest of your lifetime so that you don't have to include others in the potential sale of that real estate. It also allows your children to receive that property at a step up in cost basis because they will be inheriting it. If you were to become incapacitated, they're still going to be able to step in if it's inside of a trust and take care of you. And you've avoided all of the difficulties that people envision when they go through the probate process and the delays. If you're interested in learning more about this, give us a call.